Hi, Janice.
Hello, how are you?
I'm well, and you?
Doing great.
We have a cool one today because I am a big comic book fan guy. And today we'll talk about Stan Lee, the founder, I guess, and creator of Marvel Comics, and his tangled web of estate planning, and 9 questions you should ask on how to avoid those problems in your own life. And for anyone who doesn't know, Stan Lee passed away recently. May he rest in peace. And it turns coming out in the news that he had kind of a bunch of problems with his estate. And this article comes from marketwatch.com, written by Alessandra Malito. So thank you, MarketWatch, and thank you, Alessandra. Janice, can you start off by giving us the background information about Mr. Stan Lee's sort of estate situation and some of the twists, turns, and problems that came up?
Absolutely. And I think I can summarize it in 2 words: hot mess. That's really what this entire article is saying. So, Stan Lee, Captain America, Spider-Man, really cool. But he did pass away at 95. His wife of nearly 70 years, which that's amazing. She passed away in 2017. He was also, I'm sure you heard in the news, accused of some inappropriate behavior. And not to mention, we're talking lots of different accounts of missing money. They mentioned here $1.4 million missing from a bank account and $850,000 stolen to purchase a condo. So we're just riddled with financial drama and personal drama. In what I'm not sure how long that went on for, but it seems like a pretty long time. So what they're saying here is that these complications could lead to a mess in the estate. We don't know at this point. It's all speculation of what kind of documents did he have? What kind of setup, what kind of plan did he have? So it could be really interesting to watch this unfold, I think. What do you think?
Yeah, I mean, I think the point of this is to sort of a coulda, woulda, shoulda. And the author is talking about sort of the 9 questions Stan Lee could have asked when hiring an advisor, to help understand what could have been done to avoid all this. Is that about right, about the tone or the tenor of this?
Yep. Yes, and they do say that he went through quite a few different attorneys and financial planners. So he's had his share of people. So there may be lots of, and again, it's all speculation. There may be lots of documents floating out there that they're going to have to sift through when they're conducting his estate. So they jump into these 9 questions, which I feel very open-ended questions to really get you to think. There are no answers. So they're just the questions of like number 1, how are we going to organize and simplify my assets? Well, in Stan Lee's case, I don't know how you're going to organize anything if there's documents all over the place. We've got missing money. We have different accounts. It could be a mess. How would you suggest somebody organize and simplify their assets?
Yeah, so let's do this. I'll answer for Stan Lee. I mean, based on what limited information we have. So when you have $1.4 million go missing from a bank account, or what was the other example? Somebody bought
$850,000 to purchase a condo.
Right. So it just feels like there's a lot of loosey-goosiness with money. And that happens. I've seen that happen way too many times. What happens is when folks get on in years and they're beginning to feel more vulnerable, I've seen them add different people to different accounts, almost like diversification. So they feel like, okay, my son is on my checking account and my nephew is on my brokerage account. And this way I have a lot of different people who can help me out in case, I need help from different folks. My son is on vacation or something. The problem with that is it gets really messy and really disorganized, and it just kind of, it gets too many cooks in the kitchen or too many hands in the cookie jar. So one way you might want to avoid that or solve for that is to put everything into a trust, or at least one organized type of account. And that you have all the power and responsibility centralized with yourself and with your co-trustee, possibly an attorney or professional who doesn't have a stake in taking money out of your account.
And very important, yes.
Right. But the important thing is, because it's all centralized, there's total accountability. There's no question who took that money, where did that, who had access to the money. the all fingers point to your co-trustee, and that co-trustee bears the burden or bears the responsibility and the risk of making sure he or she does a good job managing your affairs. So you need to choose wisely, but again, all the liability points to that person. So there's no question, there's no doubt, what happened to that money.
That's great advice, which is exactly the answer to number 2. What sorts of accounts and trust will we use, and how will they be managed? As you mentioned, a trust is one option. Have your information and your documents, you're centralized, and using a third-party professional, making sure that the person knows what they're doing. These are big accounts. This is not chump change. This is really big stuff. And you said that third party, that person is held accountable. And in your case, you've done this how many hundreds of times?
Right.
Right.
And so you also want to avoid what I always see, adding a power of, there's bank accounts, at least in New York, can have many types of designations. There are bank accounts with a joint owner. There are bank accounts with a power of attorney attached. Things called Totten trusts, ITF, or in trust for accounts, TOD, transfer on death. There are all sorts of accounts you can set up. That's not estate planning. That's just, putting people's fingers in your money. You set up a proper trust with an attorney if you want that sort of centralized and accountability that we talked about earlier, not just adding people's names willy-nilly to your accounts.
So what I'm hearing you say over and over is get a professional that knows what they're doing to help you set up this plan.
Pretty much.
So this isn't something you can really wing. You have to have a professional. So number 3, how will you work with my trusted contact while I'm well and after I'm sick or deceased? And for those that are unsure, how can I pick the right trusted contact, such as a family member or professional? And I believe you've said this a few times, is professional is always best just because there's no affiliation. And like you said, you've done this hundreds of times, you know what you're doing, and you know the rules. But if it's somebody else, a family member, how will the attorney that's going to handle your estate or planning fare with the person that you're putting as the contact?
I mean, there's no universal answer here. The best answer is just to get somebody who's independent, objective, and I guess professional or just, normal, professional, nice person who's not going to antagonize your daughter or your nephew, whoever they might be dealing with. But objectivity But objectivity is huge, because if you have 2 kids and you make one the executor and the other not, you've created imbalance right there. You've created resentment between your 2 kids. Assuming that's not your goal, why not have an independent third party so that everyone, all your loved ones at least, are on equal footing? Yeah,
that's a great idea. Yes, they're all equal, and it's also the burden doesn't lay on one and not the other.
Mm-hmm.
So number 4, how do you determine cognitive decline in an individual? What practice would you take if you thought my ability to answer questions and manage funds was diminished? And what would you do once you've made this determination? Maybe you could help shed some light on that.
Obviously, this is a very, very touchy topic. So first I'll point out that there's 2 different standards of cognitive decline. One is the standard of whether or not you can make your will or revise your will. And in New York, that's actually a really, really low standard. And I think to summarize a case from the New York courts, and this is not verbatim, but it basically says that you could be a drooling, raving lunatic for the majority of your life, yet have a moment of clarity when you had the requisite cognitive abilities to change or update your will. So it's pretty low standard. As long as we can prove in that moment where you signed that you were good, the rest of the time you could be, I don't want to use an example, but very, very unwell.
Very unwell. Wow, that's interesting.
Yeah. Now, alternatively, for more day-to-day things or setting up a trust, the standard's a little higher. You would have to have what would be the amount of mental capacity to sign a contract, a non-will contract. And that's more what I think regular people think on a day-to-day basis as, being mentally able. Just what's the day of the week, who's our president, things like that, right?
Okay.
And I just kind of gave you an answer. There's a couple of just general benchmarks or questions that you can ask, both from a legal and a medical standard or perspective of what constitutes somebody who's in their right mind, I guess you would say.
Right.
So that's not something that you need to really suss out on an attorney-by-attorney basis. And what would we do if your funds are diminished? Before it got to that point, we would have set up a plan for who would be in charge of your funds and how the funds would be managed for your benefit. Most likely a trust or some sort of guardianship or custodianship. But again, it varies by state and by situation.
So it's really about having that plan.
Yeah.
So we're using Stanley's Tangled Web to ask 9 questions that we are to ask during our own estate planning. So number 5 was, how else do you practice checks and balances during the financial planning or estate planning process and during the monitoring of my assets? Again, I go back again, I keep saying that professional would know how to checks and balance it throughout the entire process.
So some people want checks and balances in the forms of like 2 co-executors or 2 co-trustees, and that can work. But in my experience, that actually causes more problems because if there's a deadlock, then nothing happens.
Right.
So great.
Then you're stuck.
Exactly. The reason I like an individual professional executor is 2 reasons. Okay. The reason you want an individual is the reason I talked about before. If you get a deadlock, then you have to go to court to resolve these deadlocks, and there's no motion, right? You want things moving along because otherwise, or even with motion, probate is very slow.
It is a tedious, long process.
As Janice knows, having helped me out many probates already. So you want motion, but you want somebody, the individual executor or trustee in and of himself is a check and balance is because executors and trustees are personally liable for any shenanigans in their, in the execution of their duties. So even if I'm a lawyer with malpractice insurance and all that, I would, if I screwed up or stole money or not me, but some other attorney, I'm great.
Right.
That attorney could potentially have to pay out of their own pocket, meaning a lien on their house or out of their own savings for any mistakes that they made. So that's the check. You have huge personal risk, right? And the reason you want it to be a professional executor is because professionals, attorneys, sometimes CPAs, are keenly aware of these risks. So if you have like a nephew or a cousin who's serving as executor or trustee, that risk is on them, but they might not get it.
They might not understand the gravity of that risk. Right.
So even though they have legal liability, they're still just kind of lollygagging around with the estate checkbook, just because they don't really quite grasp what they should be doing and how it can impact them personally. They don't understand it. So that's the reason why I think.
Absolutely.
Yeah.
So they say, how often will we review beneficiary agreements and estate planning documents? And you have mentioned before that this is like the Olympics. Every 4 years you can revisit them, not by any length or take a lot of time. Just look them over. Maybe talk to your professional and just make sure everything is fresh and up to date and that there wasn't anything in between those 4 years that needs to be addressed.
So that 4-year rule, Janice, is something I recommend for, I guess, some sort of mid-career individuals. If you're 95, as Mr. Stanley was, it might be an annual thing, a little more frequently, because just things seem to change. Health issues pop up. And just, it's my experience that older clients want to look at them more, and so why not? Yeah.
Okay. Yeah. And based on what they were talking about, is he had a lot of stuff going on in the years leading up to his passing. So
just be aware. Just be aware that anything more than even annually is a bit much. But showing a long audit trail of constant changes can actually reflect on how competent you were. I mean, if you're constantly changing your mind about stuff, that doesn't look good to a judge at the end of the day. So you want to show some level of consistency.
That's a good plan. Yeah. Number 7, do you work with a team of professionals, and in what capacity? And how often will I work with them too? So that's a great question of how is your business set up? Which I find that interesting to ask when you're talking about estate planning.
Yeah.
What do you think about this one?
You want to work with somebody who has a team. I mean, there's a lot of solo attorneys out there who are probably really intelligent and very experienced, but when they're on vacation, that means nothing happens. Yeah, I mean that's not comforting to you. You want and estate planning, just like most things in this world, is getting very, very specialized. It's really not fair to say that any one attorney can be good at estate litigation and will drafting and probate and administration. There's just so many elements. I know most people don't understand what those words mean, but my point is that there are a lot of different subsections of estate planning and probate. Yeah.
Every one of those words is completely specific and is very complicated and has many moving parts.
Right. So it would be very tough to imagine any attorney who's good, who's excellent at all of those things, right?
Right.
So you want to work with somebody, for example, I would say my strength is executorship and reading the terrain, serving as that objective person for my clients. And then if it gets into areas such as litigation where, okay, look, the heirs are going to sue each other, I have colleagues, a team of professionals who I can bring in to really, run the point on that. And you want to have somebody who
have their specifics. Perfect. So number 8, which is, I'm going to ask you this question because the answer to me would be interesting. So number 8, should we ever include my family members or beneficiaries in our conversations? And if so, when?
Sure. I mean, it's up to you. If you're going to include them all. Like I said, bias or the appearance of bias can cause huge problems later. So if you have 4 kids, and unless you're just hard, you've made the hard decision to completely exclude one or some of them, include all of them in all conversations, right? But yes, aside from that, having these conversations while you're doing the planning, well before you're on your deathbed or anything like that, that's fine. I mean, setting up the expectations way in advance is very useful. Just be aware that people forget and people's memories are flawed. So if you're going to do this, don't think, okay, now it's good. They'll always remember that I said that. That's not necessarily the case. No. You might have to reinforce.
And make sure it's in writing, not just anything verbal. And then number 9, to finish this up, is, do you have any references I can speak with? So I interpreted this as, do you have references or other clients that I could speak with about your work? That would be my interpretation of that. How do you feel about that one?
Yeah, that's kind of useful. So here's the reason why I kind of pause on that. Client references are great, but here's the funny thing. You have no idea if your situation or your needs are similar to your friend's situation or needs. So he can say, oh yeah, I worked with Joe Lawyer and he did a great job on my mom's estate. You should use him. But his mom's estate was this huge contested litigation that required a lot of, like a courtroom brawler, right? Oh. But your situation, Stanley, or whatever, right, is a lot more nuanced and requires a lot more savvy in terms of dealing with the banks and getting things done. Those are 2 completely different skill sets. So your friend's recommendation of Joe Lawyer, it was sincere and was authentic, but it might not be the right fit for you. And most people don't know the difference. The clients, because, they just don't know. That's why they hire lawyers. So I guess, you get those references for professionalism. And people
that's a great idea.
People who are good to work with, who get along with that, they can definitely vouch for. But in terms of if they're the right kind of lawyer for you, that's really hard to say.
Okay, so maybe going off of asking the attorney himself what he would specialize in and what he's, well, like you said, what you're good at, which you do all the time, and then using the references for like personal information, so much as, did they contact you back, and how were they in the overall process of whatever they were doing?
Agree. Yeah.
Yeah. Yep. I like that. Just to kind of give you they were really great, or not so much. But on the flip side of that, couldn't you, if you're going to give someone a reference, you're most likely going to give them the client that's going to give you the highest praise. So you probably have to take it with a grain of salt anyway. Yeah,
I only have clients who give the highest praise. So.
That's true.
Just kidding.
Absolutely. I mean, right. Absolutely. But, I guess you have to take that with a grain of salt. You're not going to say, oh, here, called, Jane Smith and she didn't like anything I did. So anyway, the flip side of that, just take it all into consideration, everything. Their history and what they're good at, and take it all as a whole complete package.
All right. I think that's it, right?
I think that's it. We hit all 9.
So I hope Stanley's estate is sorted out nicely, not only because he created so many wonderful characters for the world to enjoy, but because I wouldn't want any estate problems holding up the production of new movies or comic books, because his estate controls the copyrights. And
yes.
Anyway, all right. So thank you, Market Watch. Thank you, Alessandra Malito, and thank you, Janice, of course.
Yes, we'll talk soon. Maybe we'll talk soon about what actually is occurring in his estate when we get more information.
Yes. Comment or social or whatever. Let us know if this is interesting to you, and we will definitely follow up. Until next time. Bye, Janice.
Bye. Talk soon.